think we are there. Okay, good afternoon. This is the Banking, Consumer Protection, and Commercial Law Subcommittee meeting. It's March the 15th. We're going to be discussing HB 259, Commercial Law, Consumer Protection, Biometrics, Identifier Privacy Bill. So I'm going to now turn it over to Counsel Tiffany Clark to kind of walk us through the changes we've made. Thank you.
Okay, thank you, Madam Chair. I'm going to share my screen now. Can everyone see the reprint? Is that a yes? I'm sorry.
Yes.
Okay.
Yes,
Because I can't see you guys, so hold on 1 second.
it's on the screen.
Okay. And I'm moving it. You're seeing me move it, right? Okay.
Yes. Can you make it a little bit bigger for those of us that wear glasses and
Okay.
can't see?
Is that better? Is that okay?
That's better. Thank you.
Okay. So this is the reprint of HB 259. It takes into consideration some of the things that we discussed. I guess that was at last week's meeting. I'm just going to go through the reprint on the screen, and if there are changes that need to be made, we'll be able to make them on the screen. So right here, these are still technical changes. All the way down here, we talked about this yesterday. This information here that's stricken, this is the definition of biometric identifier, which we switched with the definition of biometric data. Now down here, this is page 3, line 9. We have the definition of personal information. This was brought up at the last meeting about why personal information was in there and described this way. So the definition of personal information is stricken, as well as any references to personal information in the bill. It's just not necessary. Okay, now here we added a definition for consent. This definition, I will read it, and it says consent means a specific, discrete, freely given, unambiguous and informed agreement given by an individual who is not under any duress or undue influence from a private entity or third party to collect, use, disclose, redisclose, or otherwise disseminate an individual's biometric data. Consent includes a written statement by electronic means, and in the context of employment, a release executed by an employee as a condition of employment. So, and you'll see further down the reprint, the definition of written consent is stricken, and we just have this version of consent, which takes into consideration electronic means. There was concern brought up that certain types of, like for instance, if you're going to use like Alexa or something like that, we would have to have written consent, whereas you could have consent on an app, and that would be acceptable through this method. Does anybody have any questions about that? No, okay. We'll keep going. As I said, written consent is stricken. We have here a definition of sell. There was also concern about selling, otherwise profiting, and all of that. I will get into that further as I go down, but here is the definition of sell, and it means the exchange of biometric data for monetary consideration by a private entity to a third party. Sell does not include the disclosure of biometric data to a processor that processes, stores, or or otherwise uses biometric data on behalf of the private entity or a third party for purposes of providing a service or product requested by the consumer. Okay. So all of this we discussed last week. This looks like a big section was taken out, but it was actually just moved. Now, this section, again, some things were moved around. So none of this is added. It was just moved from a different section to provide clarity and just better flow. Now, when we're going to start entering some changes, it's right here. So what I did, I wanted to make it clear that a person using this for fraud or security purposes would just have to provide the notice in a conspicuous place at the point of collection. And I think there was some confusion about whether they would also have to get actual consent. And so what I did is it says, except as provided in paragraph 2 of this subsection, a private entity that collects biometric data may not collect, use, disclose, redisclose, or otherwise disseminate an individual's biometric data unless the individual or the individual's legally authorized representative gives consent to the particular or category of collection, use, disclosure, redisclosure, or dissemination, or the disclosure or redisclosure is required by a valid warrant or subpoena. This part is added to comply with federal, state, or local laws, rules, or regulations, or to cooperate with law enforcement concerning conduct or activity that the private entity or the processor reasonably and in good faith believes violates federal, state, or local laws, rules, or regulations. So this part was added just because there are other reasons. If somebody has to follow a law, they should be able to disclose that information. So this section here, a private entity may collect, use, disclose, redisclose, or otherwise disseminate an individual's biometric data without complying with paragraph 1 of this subsection if the private entity collects, uses, the biometric data for fraud prevention or security purposes and posts conspicuous written notice of the collection of biometric data at the point of collection. So that part was added, like I said, to make it clear that if the entity is collecting for fraud or security purposes, then they don't have to comply with paragraph 1. All they have to do is put a written notice at the point of collection. This information here looks like it's stricken. It is not stricken. That's part of the language that was moved up to another section. Oh, and my apologies. I actually skipped over the selling part. I'm sorry. It's kind of hard to follow on this. My apologies, everyone. So right here, where it's where there's some highlighting, it says a private entity that collects biometric data may not sell, lease, or trade an individual's biometric data. So there was concern about what or otherwise profit means. And in my research, there is some severe issues with that language. So that language was struck. And that's why we put a definition for sell. And it's a point that I would like a little bit of contribution on. I don't know if I want to put sell, lease, or trade, or lease or trade in the definition or sell, or if it is acceptable just to have sell, lease, or trade by itself. If anybody thinks that's confusing, we can talk about that after I've gone through the reprint. And we'll go back down. Okay. And then here, this is this section here is about what an individual can request. Oh, I think there's Madam Chair, I think there's a question from
I can wait till the end. I'm just getting ready.
Okay. So this part here is about what an individual can request from a private entity related to their biometric data free of charge. And so what we have here is the categories of biometric data and the purposes for which the private entity used the biometric data. So there's a number of things that are stricken because they related to personal information, which doesn't really fit in this bill since we're only dealing with biometric data. So a number of sections were stricken in this part. And then if you see B here, we have to the point, I believe it was Delegate Watson brought up, what if someone is requesting all of these, all of this information multiple times per year? So I added a section that says a private entity may not be required to provide an individual or the individual's legally authorized representative with the information in subsection A of this section more than twice during a consecutive 12-month period. Again, this is something else to discuss. If you don't think twice is enough, we can just, change the number, or if you would like to authorize them to charge for it, we can discuss that as well. And then down here, nothing was changed from the last time we spoke. So that's what the additional amendments do.
Sorry. Okay, so I will, I guess, start to entertain questions. Delegate Watson, then Delegate Adams.
Thank you, Madam Chair. I think that the twice a year is fine. It certainly addresses the issue we were talking about. And I would leave lease or trade in the language. I like the fact that you just struck otherwise profit from, but I think sell, lease, or trade is reasonable to be in there. That's it.
Okay, thank you, Delegate Adams.
So is the private right of action still in this bill? Has that been changed?
No, not from how we discussed it. I guess that was last week. So basically it allows for a private right of action if someone sells, leases, or trades the information. If there's a violation of anything else, it goes through, well, both are actually through the Attorney General, but it's just an unfair, abusive, and deceptive trade practice. And those penalties that flow from that.
So counsel, let me just say, and then I'm going to move on to my next question. I simply do not know how the private right of action adds value to legislation like this. If it comes to the point where the Attorney General's office is saying, oh my goodness, there are all these examples of why we need this, then maybe you revisit it. But I mean, this is a pretty significant law that really I would not hand private right of action. This is class action lawsuits, not with a testimony from Illinois. That's a position statement, not a question. The other question does go to the terms lease and trade. And so as we're talking about other states that have had problems with this bill, how are other states defining lease or trade? And then frankly, how do you define it in this bill?
Okay, so Illinois is the state that had the issues with sell, lease, trade, I think, and otherwise profit. And there were a lot of lawsuits from that. The other states who use this include lease and trade or language similar to that in the definition of selling, if that makes sense. Let me see, I believe this is from the California Consumer Protection Act. They say sell means selling, renting, releasing, disclosing, disseminating, making available, but they don't define, or they don't explicitly say leasing or trading. I think it's just different terms for the same thing. So what I was saying when I was going over the definition of sell is that I can put lease or trade into the definition of sell so that we do have a definition for those terms.
Well, so you're using the word trade and lease, frankly, as a descriptor of sell, not necessarily defining what lease or trade actually mean. Okay. So in other words, if you ask the question, what does sell mean? Your answer is, well, in the bill under sell, we are going to describe it as being leasing and trading, which that doesn't really get to the nut of the question, which is important because after you get to the lawsuits, come the ambiguity to legislation that would beg the lawsuits. And therefore, I believe that a definition of trade and lease need to be part of this bill. I don't know if you'd agree with that, counsel, or not.
May I?
I'm interested in counsel, but I think that the problem with the bill, if we're going to try to fix it, is not going to come via subcommittee. If we're going to move the bill as it's amended, I'm just trying to resolve what I think are some these are my two big problems with the bill: definitions and why we're insisting on private right of action. So, counsel, unless you think we can dial in lease or trade, I'll just say that I have some real concerns about that, especially if we're going to keep private right of action involved.
So I guess I would like to maybe in this case have the Office of Attorney General weigh in, because most of these issues would be their office handling them. So I would probably like to hear their perspective on that. That would be okay.
Okay, sure.
Thank you. So for the private right of action, as it's currently drafted, it's limited to actual damages. So to the extent that there is a sale of biometric data in violation of this law, the consumer would have to establish that they were actually damaged. They can't get penalties. They can't get any other forms of compensation. So it's a very, very limited remedy that is, and it's in Illinois that it is not limited this way. So I would distinguish it from any experience that we can talk about in Illinois. That is different.
May I respond to that real quick? So it may be more limited than the law in Illinois, but the question is the opening that we have in this law, how they're actually using Illinois' law. In other words, are they getting, it's the same problem. It's just we're narrowing our bill, but not in a way that's helpful. So for example, private right of action is class action lawsuits. It's attorneys getting rich, and do the consumers, the ones that are actually harmed, actually receive the financial benefit? I already know the answer to that. The difference between a private right of action and the attorney general bringing the case is that the attorney general is the advocate for the consumer. That's the difference. So I'm sorry, go ahead.
No, I would just say that to the extent that the attorney general is able to bring a case, it's only if there's a pattern or practice. There has to be a broad ranging, but if an individual consumer was individually harmed, actually harmed, then there is a rationale for providing them with a remedy so that they can get compensation for it. It is not both the scope of what a consumer can pursue an action for is in Illinois. It's also collect. It's much broader than what this is drafted as, and it's also the actual what the consumer has to establish in order to get compensation. So I would distinguish this. This is not what Illinois provides for in any way, shape, or form. In terms of your second question about sale or lease or trade, first of all, at least California, I believe, includes in the definition of sale the monetary consideration or other valuable consideration. So there is a way of grasping it in that definition. And I think the issue here is to try to, and they don't all include definitions of sale in the specific biometric bill. They might have it in other contexts in their legal structure. I think the issue here is you also don't want to get into a situation where you're providing biometric data in exchange for services or anything like that, because that just becomes a way to get around the current definition of sale, which is limited to monetary consideration.
Madam Chair, thank you for helping get the clarification. I'll park for right now and just listen in to other questions.
Sure, no problem. Delegate Mouse, then Delegate Harrison.
Thank you, Chairman. So what states, what are the neighboring states that have this law in place right now?
There isn't a state that has this particular law in place. Virginia has a comprehensive data privacy law. And then Illinois has a biometrics piracy law, and California has a comprehensive law. Texas has a law, and Washington State has a law. I believe there might be one more, but the closest one is Virginia, and that is a comprehensive just general personal information and biometric privacy law.
Privacy law. And I just want to make sure the section that is identifying what is described as biometric data is section C, numbers 1 through 8. Is that accurate?
No. So can you still see my screen?
Yeah, I'm right there. I'm on the hard copy, right with you.
Okay, this is the definition of biometric data. So data generated by automatic measurements of the biological characteristics of an individual. Sorry, it cuts off individual, such as a fingerprint, voice print, eye retina, iris, or other unique biological patterns or characteristics that is used to identify a specific individual. And then it has what it does not include.
Right. And I'll just throw it out there because I know the like the casinos use a lot of this technology, right?
Mhm.
And are they comfortable with the provisions that are included now with the amendments, or do they still see problems?
I haven't heard from any casino, anyone, quite frankly, about the amendments except for one person. So,
Okay.
and we had these out since, I don't even remember when we met. Thursday, when, I don't remember. I'm sorry.
Okay. That's my questions. Thank you.
I just want to ask, I know I said Delegate Harrison next, but Delegate Fennell, you had your hand up and you need to leave at 2:30. Are you good?
Actually, I'm good. You know, I don't like to be redundant when somebody else asking a question. Thank you, Madam Chair.
Oh, okay. All right. Delegate Harrison, sorry about that.
No worries. Thank you. I appreciate it. A couple of questions. So, well, this reprint was just with these latest amendments was just distributed today, though, right?
Correct.
Yeah. Okay.
But the amendments regarding the casinos. and
Okay.
Done
what they-
before.
That was
That was in the last
that was
version.
in the previous version.
Yeah. Okay. So, a couple of questions around like law enforcement, and then there was I used to be in a previous life. I was a defense contractor, and of course, you know, when you go to try to get a clearance, you've got to go through all kinds of, you know, background checks, et cetera. And so I know that for human resources, that is in here and implied in here if they need to do that. So, but perhaps there's a contractor, a third party who's doing that. Is that considered the processor? And the private entity then would be in the case that I'm giving as a defense contractor. So I would have been contracted with, let's say, Defense Information Systems Agency, and perhaps they had someone who was doing the background check. Would that group that's doing the background check be considered the processor, and the Defense Information Agency would then be considered the entity? Of course, they're not private, but you know.
Okay, I was about to say,
Yeah,
they wouldn't be covered
not
under this.
No.
But yes, if you have someone else storing, processing the information for you, then they're a processor. And there's still some parts of the law, where are we? Hold on, let me see. There's a section that specifically discusses what processors.
Yeah, let me see. So my scribble note to myself is under section 144401, and then I had F.
Oh,
So-
okay. It's on the screen right now about processors and their relationship to private entities. So that's what's highlighted right there. A private entity that contracts with the processor to process or store biometric data may not allow the processor to collect, store, process, use, disclose, or conduct any action for profit or otherwise on or with the biometric data except for purposes for which the private entity received express consent from the individual, and a processor may not collect, store, process, use, disclose, or conduct any action for profit, or should take that out, or otherwise, or on with biometric data, except as authorized by a contract with a private entity that legally possesses the data.
Okay, so does that fall? So then using that sentence where particularly when we talk about conduct any action for profit or otherwise, is that considered the otherwise profit?
Well, I missed this part. I'm going to take that part out and say for monetary consideration.
Okay. And then, so specifically the one that I was referring to is on this reprint that we're looking at is page 3 and down at line 28, where it gives, I guess, the definition of a processor.
Yes.
Okay. All right. So then that's handled. And so essentially anyone, who needs to assist law enforcement, then this would not apply to them, correct? If there is,
if it's a processor for law enforcement, since I guess they're local, they're not a private entity. So it wouldn't apply to them, even if it's the processor for the entity.
Okay, so and I think that, and I don't have my page numbers right, but we did talk about that if there is, I guess, a warrant or a subpoena for some information, then they would be required to provide information. So they would essentially be cooperating with law enforcement. Is that correct? Okay.
Correct. So this section, I'm sorry, I keep pointing like you guys can actually see what I'm pointing at. Here, this is new 14405, which says, basically it says a private entity that collects the data has to have consent unless the disclosure or redisclosure is required. We had a warrant or valid subpoena, and then I added to comply with federal, state, or local laws, rules, or regulation, or to cooperate with law enforcement concerning conduct that they believe is illegal, basically.
Okay. All right. I think that's it for me. Thank you.
No problem.
Okay, Delegate Adams.
Thank you, Chair. And I guess this goes back to the Attorney General with a question, if you don't mind. Last time we were discussing, there were some elements of this bill that allowed or required the Attorney General to determine whether a company was in a certain format where the law didn't apply. I was listening to Delegate Harrison because I thought she brought this up last time, but is this asked and answered, or has this been part of the reprint as to how that is further clarified or not?
That section is taken out.
Okay.
Of this reprint.
Okay, because I'm only partially following. How does that affect this bill now? Are there no exemptions, or is the Attorney General not?
No. The only reason why I put that in there was because I thought maybe if somebody was using it for fraud or security purposes, but they weren't really, they were just saying it, that the Attorney General could stop it at a certain point. Because the long and short of it was, I had in my mind a whole process that maybe they would apply to the Attorney General to do, to figure out if their fraud or prevention security usage is appropriate, and then they could do it. And then I backed off of that and still left in that the Attorney General would be able to determine whether they're using it appropriately. I took that out because, I'm sorry.
No, thank you.
Okay, so I took that out because now, let me move down. Okay, since it's an unfair, abusive, and deceptive trade practice, and they already have authority to investigate things that are unfair, abusive, and deceptive trade practices. So if somebody brought this up to them, they would already have authority to go in and look to see, were they really a fraud? Were they really conducting fraud and security or not? It's not necessary to put it up there any longer since there's no actual process that they have to do beforehand.
So I'm working really hard to follow, but I'm going to ask a follow-up to that, council. So are there exemptions for biometric data used for security or anti-fraud purposes?
I don't know if I would say exemptions, but they do not have to obtain written consent or electronic consent if they're doing fraud or security. What they would have to do.
So for example, how
You
about
tell them in my subcommittee meeting and
I can't hear.
I'll look at it.
So for example, what about identity verification? By way
So like if you're walking into somewhere and they're doing your
yes,
or verifying your identity, then they would have to post at the point of collection, by the way, we're going to take biometric identifiers. This is what we're taking. This is why we're taking. And the thought behind that is if you don't want your biometric identifiers taken, you can leave.
got it. Hannah, did you want to say anything? I thought you may have wanted to chime. Okay.
No, the council is correct.
Okay. All right. Madam Chair, I think I've asked, this is a lot of change, by the way.
It is. It's a lot of change. And we, as I alluded to when I first started, that council has been working a lot on this, trying to address all the questions and issues people have raised. And as we alluded to last time we met, that we've looked at, the bills in other states and tried to find the best of all the ones we've seen out there. But at this point, I know this is a bill that has had a lot of questions and certainly have had questions from others in the on our committee. I like to take it to the whole body if we've gotten most of the issues out and let us vote it there, because I want to make sure I've gotten all the voices, if that's okay with us here, that we'll take it to the body to vote on this week.
Would you
Any
like a
thoughts on
motion?
that?
Move favorable in subcommittee?
Before
Seconded.
we do that, Madam Chair,
Sure.
and we can take this offline or we can just wait for the full committee to discuss it. But I mean, my biggest hang up on this bill by far is the rationale behind the private right of action. Is there any way that the committee would consider, before we move this to the full committee, consider whether or not it's a real necessity to have that in this bill?
I guess I would ask council to explain why that has been left in with all the dialogue. What was the thoughts behind that? You may have more rationale on that.
I mean, I think it's been explained. It's just that the thought is that the selling of the data without your knowledge is just so patently
Egregious.
offensive and so egregious that it deserves a private right of action. Everything else that's in this bill, nothing that's not private right of action. There's just a very, very, very small part. And we're trying to make it as clear as possible by, defining sale and all of that so that people really know what they're getting into. But there's nothing else really to say, except that's the thought process behind why it's in there and why it's in there for that very little portion of it.
Office of Attorney General, any thoughts on that as well?
Yeah, I would just add that there is currently a private right of action for violations of our Consumer Protection Act. And it isn't at least no one has ever raised to me that it's a class action problem and a target in the way that other states have it because of its limited form and its tie to actual damages. So it really has tamped down on that issue in the way that it's structured.
I would say the difference is that the Consumer Protection Act, what you're talking about.
If I can follow up on what Hannah said, the Consumer Protection Division doesn't represent individuals. So as Hannah previously stated, we'll be able to we'll bring an action generally if there's a pattern or practice that affects a number of consumers. But if you have an individual consumer who's been harmed by the release of their biometric data, we would not be representing that individual consumer. So they would, need to have the ability to bring their own action for a violation. We can't represent everyone. We can't bring every single case that's out there. This allows individual consumers who have been harmed to be able to seek compensation for damages they suffered.
Delegate Harrison and then Delegate Motz.
Yes, just for my clarification. So at this point, the way that the bill is currently structured, the only part for private right of action is if a private entity sells, trades, or what's the other word?
Please.
Sell, trades, or leases the information. Is that correct?
That is correct.
Okay, thank you.
Delegate Motz.
There's somebody's got some music playing or something. There we go. So I'm just following up what Delegate Adams was talking about. I get what we're doing. I get the point of this because I don't like people collecting my information. But the reality is being able to bring a civil action to change the course of practice is going to have no impact. And really, when you get to the point that your information is stolen and used, you'll never get it back. So there's no lawsuit that'll ever make you whole. And I believe that's the argument behind, why are we having a civil action here? The only person that wins in a civil action in cases like this are going to be lawyers, and it's not going to be a tool really to deter bad actors. And to that extent, this is probably more on the bill than actually try to amend it. But to that extent, is that the state of Maryland will have jurisdiction over enforcing this law, and the question remains is whether they'll actually be able to do anything, because there's so much information. It's so voluminous. There's so many different instances. It would shut the Attorney General's office down to try to bring one of these cases against. Ultimately, you get down to it, you're going to be battling, litigating against one of the bigger corporate entities in the world, probably, because those are ultimately some of the folks that have this type of technology. And I just think that civil action concept that Delegate Adams is bringing up it isn't going to bring any benefit to you and I as we're going through places. Our biometric people have got our stuff. They just haven't figured out how to use it enough, which is why we haven't really been affected by it. But I understand the principle of what the bill is trying to do, because I'm constantly, before I became a public person, I didn't let nobody knew. You couldn't find Johnny Mounts on the internet, and but the reality is that this stuff is already being collected. It's out there. And then what is the best public policy? And the idea that the civil suit aspect in this, I think, is an illusion at best, an oasis. People, you're never going to be able to you will never be made whole. The civil action is not going to remedy your situation once whatever it is sold. And the idea of we're going to protect people's privacy, I think that's great. I also think there's a big problem in that, to try to get to the bottom of one of these cases, it's going to be really hard for the Attorney General's office. And I just wanted to share that with everybody. It's more on the bill than it is a specific question. So thanks.
I appreciate that, Delegate. Thank you, and we'll take that in mind. So again, I think we'd like to move. So have someone to move this favorable to come out of committee, and we can have some more dialogue later. Delegate Watson, did you move the bill?
Madam Chairman, make sure you have the votes.
Yes, I moved the bill.
Seconded.
Thank you. It's been moved and seconded that we will move this bill out of committee. We'll now take the votes. Council, you're going to do roll call for me, please?
Sure. Are you going to vote, Delegate Chair?
At the end.
Okay. Delegate Adams.
No, and I'm surprised we're going to that on the private right of action, because it could have been different. Okay, just saying.
Delegate Harrison.
Yes.
Delegate Fennell. Is she?
Yes. Yes.
Delegate Jackson.
Yes.
Delegate Mouts,
I'm gonna go no also.
Delegate Pippi. Is he here?
He had a hearing. He may have left.
Okay. Delegate Rogers,
Yes.
Delegate Watkins,
Yes.
Chair Queen.
Yes.
Okay. 1, 2, 3, 4, 5. 5-2.
Okay, so I'm assuming we will have more debate about this, but I think we've done the best we could as a subcommittee to try to address most of the issues, and we'll see where it goes.
Chair, thank you for the opportunity. Allow me to go long on this bill. Thank you.
No problem. We always appreciate the debate. Thank you for your time.